Hi everyone, welcome to LearnerBee. Today we have Shamila from CAS International to bring us the topic Patent Rights Beyond Malaysia, the Way Forward. So let me do a short introduction about our speaker here today, our beautiful Shamila here. She is a patent executive from CAS International. So what does CAS International do? They provide advisory and consultation services in all intellectual property issues, including filing, prosecution, and maintaining IP rights, including patents, trademarks, industrial designs, and also copyright. So they also draft IP related documents. So they do all sort of IP stuff. So if you need help in terms of IP stuff, you can go to CAS International to seek their services. So Shamila, I'll pass the floor to you. Okay?
Thank you,
Good luck.
Rachel. Yeah. Hi, hello, good morning, everyone. I am Shamla Pranayandi, as introduced by Rachel just now. Our topic for this day is on patent rights in Malaysia. So let's look into the slides. Okay, let's see. How do we obtain patent rights not just in Malaysia, but in other countries as well? For the uninitiated, patent rights are exclusive rights awarded to an inventor in exchange for disclosing an invention that is new, inventive, and industrially applicable to the public. This exclusive right allows the inventor to exclude a third party from exploiting the invention. The right is not indefinite, but only lasts for 20 years. Okay, let's see. How are these rights automatically awarded? Do you have to register your invention to obtain the patent rights? What if you wanted to obtain the patent rights overseas? Is there such a thing as an international patent? Consider the following. B has drafted and filed his patent application via his patent agent, Mr. K. During their initial meeting, Mr. K has advised B that if B wants to get a patent coverage overseas, he has to file a corresponding patent applications in other countries as well. Mr. K informs B that he may file an international patent application via a system called PCT. B likes the idea of an international patent. Can we obtain international patent coverage by filing a PCT application? Second case, after 7 years of back and forth correspondence with the Malaysian Patent Office, a hearing and an appeal, C is finally granted a patent by the Patent Office. It is also at this time that C discovers that his invention is highly sought after in Philippines. C now decides that he wants to register his granted patent in Philippines. Can C do so? Third one, while on a honeymoon in the Maldives, D fell in love with the stereotypical powdery white sand and crystal blue sea. Tragically, his wife died a few years later, and he decided to move to the Maldives to start anew. Inspired by the warm breezes and the constant sunny weather, D invents a thermal solar desalinating apparatus. Can we obtain a patent in the Maldives? What about the rest of the world? Okay. To let us understand this topic further, we will be covering the following points: how to get a patent in Malaysia, how to get a patent overseas, the fork in the road, Paris Convention or PCT. And the last one is patent filing considerations and strategies. Okay, let's see how to get a patent in Malaysia. The patent application process is not a straightforward registration process. whereby one merely walks right up to a counter with a completed form and payment and then receives the patent after 5 working days. Applications are generally examined by the Patent Office to see if they meet all patentability requirements before the patent is awarded to the applicant. If they do not meet patentability requirements, opportunities are given to the applicant to correct deficiencies in their application. This process can take approximately 3 to 5 years, so one needs to have a deep reserves of the endurance and funds. And more importantly, one needs to have an invention that is patentable and worth patenting. With that being said, how do you kickstart the patent application process? For every patent application, you need a patent specification, the relevant forms such as a request for grant of a patent which contains name and address of applicant, name and address of inventor if applicant is not the inventor, name and address of service of the agent if one is appointed, a power of attorney, a statement indicating how the rights to the invention as transmitted from the inventor to the applicant, and the last, the necessary payment for the fees, of course. Let's see the contents of a patent application specification. A patent specification is a legal document that detailing the invention and what features of the invention you would like to have exclusive rights over. The specification generally contains a title, a statement indicating the technical field which the invention falls in, a background describing the state of technology and the technical problem to be solved, a summary of what the invention is all about, a brief description of the figures, if any, a detailed description of the invention describing preferred embodiments of the invention, claims which define the features of invention over which exclusive rights are sought, an abstract giving a short glimpse of the invention and figures if there is any. Typically, your patent agent will assist you with drafting of the patent application specification. When drafting, the applicant is not allowed to amend the specification to include new matter. So, if the specification for the patent application was improperly drafted, there is little that can be done to salvage the application in the event the patent examiner finds that the information disclosed in the specification is incomplete. After back and forth discussions with the patent agent and the inventor is satisfied that the specification captures the essence of his invention in all its glory, the claims are as unavoidable as death and taxes, and the drawings are drawn in black lines, only without any shading, the next step is to file the patent application. The application must also include a request for a grant of patent, and this request must include the name and address of the applicant. If the applicant is not the inventor, the applicant must provide the name and address of the inventor and a statement indicating how the rights to the invention have transferred from the inventor to him or her. Generally, this applies to inventions that are created by an inventor in the course of working for his or her company. Under Malaysian patent laws, the employer is deemed to be the owner of the invention unless the inventor is not employed to invent for the company. In some other cases, the inventor may not be the employee of the applicant and has to assign the rights to the invention to the applicant. The application form must also indicate the agent who is representing the applicant and a power of attorney that authorizes the agent to act on behalf of the applicant. Last but not least, the fees must be paid together with the application. Now, after the application is filed, the Patent Office will examine the application to ensure that the documents and payments are in order. Any deficiencies found with respect to the documentation or payment will be communicated to the applicant, and the applicant will have 90 days to correct them. Failure to correct these deficiencies will result in the application as being deemed withdrawn by the applicant. Within 18 months from the date of the application was filed, the applicant must file a request for the application to be examined substantively. If this is not done, the application will be deemed to have been withdrawn by the applicant and will not progress any further. After the 18-month period, the application will be examined to see if the invention that is claimed in the application is new, inventive, and industrially applicable, as I have informed earlier. The examiner will compare the invention with information from other patent documents, research publications, white papers, and other types of literature that is available to the examiner. If the invention that is claimed in the application meets all patentability requirements, the application will receive a clear report and a patent will be granted to the applicant. Otherwise, the applicant will have to submit a response to correct any deficiency which is highlighted by the examiner. The examiner will consider the response, and if the response addresses all the deficiencies raised by the examiner, the application will be allowed to grant. Otherwise, the applicant will have to present further arguments and further amendments if necessary. This back and forth communication with the examiner will continue until the application is allowed, or if the applicant fails to overcome the same objection twice, in which case the application will be rejected. After the patent is granted, the patent must be kept in force through payment for annual fees, known as annuities. Payment must be made a day before the anniversary of the date the patent was granted at the latest. Now moving into the second part of today's webinar, how to get a patent overseas. Now a patent right is territorial, meaning that a patent only has effect in the territory where it is granted. The question now arises, how do you obtain patent rights in other countries? Essentially, you only need to repeat the same process in the country where you are interested in obtaining a patent. While there are procedural differences from one country to another, the general flow is more or less the same as I described earlier for Malaysia, and your application will have to meet patentability requirements of that country to be awarded a patent there. Once the first filing done, the applicant may use two routes to file corresponding patent applications in the countries of their interest. The routes are Paris Convention or Patent Cooperation Treaty, known as PCT. Now let's move into the third part of today's webinar, the fork in the road, Paris Convention or PCT. Now that we have an idea on what is procedure for obtaining patents in Malaysia and other countries, the question that we will ask ourselves now is, how do we extend our Malaysian patent application overseas? Does the applicant simultaneously file application in various countries? Or does the applicant file an application in Malaysia first, see how things go, and then only decide on whether to apply for a patent elsewhere? Before one proceeds further, a concept bears consideration, which is the concept of priority. Patents are awarded to the applicant who files the application first. For anyone who files an application for the same matter afterward, the later applicant will be given lesser priority than the earlier applicant. Based on this logic, an applicant would theoretically have to file application into all the countries where he or she wants to obtain a patent. Otherwise, the applicant would risk losing their priority to a local applicant if the corresponding overseas application was not done in a timely manner. But is this so? Patents must also be new at the time when application is filed. If the Malaysian applicant launches his or her product a day after he or she has filed his or her patent application, any patent applications that are filed after that would no longer be novel thanks to the product launch. Again, based on this logic, an applicant would theoretically have to file application into all the countries where he or she wants to obtain a patent. Otherwise, the applicant would risk losing the novelty of his or her overseas application. Again, but is this so? The applicant need not lose sleep over these issues as Malaysia is a contracting party of the Paris Convention for the protection of industrial property. Under the convention, an application that has been filed in a member country will enjoy the same priority date when filed in another member country. So, if your patent application in Malaysia was filed on 3rd July 2019 and you later on file another corresponding application in Indonesia claiming the priority of your Malaysian application, your Indonesian application will enjoy the same priority date as your Malaysian application, which is 3rd July 2019. So, if someone in Indonesia applied for a patent on the 4th July 2019, your application will be prioritized because it follows your Malaysian priority date. By claiming priority of your Malaysian application, any documents or disclosure after that will not be counted against your application. So, if you launch your product after filing your Malaysian patent application, the product launch would not affect the novelty of your overseas applications. However, there is a time limit in place if you wish to claim the priority of your initial application. All corresponding applications must be filed within 1 year from the date of the initial application, failing which the priority of the initial application cannot be claimed. So it is not advisable to wait until your Malaysian patent is granted and then you decide to file a corresponding application elsewhere. By that time, the opportunity to claim the priority of your Malaysian application would have long passed and a new application not claiming the priority of the Malaysian application would lack novelty. Filing a corresponding application overseas while claiming the priority of the Malaysian application via the Paris Convention is rather straightforward. The applicant only needs to file the corresponding application in the country of his choice within 12 months from the initial priority date. After the application is filed, it will progress normally along the country's prosecution path. But what if you are uncertain of your chances of your application being granted a patent? Or what if you need more time to test the market? Or maybe cash flow is tight and you need some more time to raise the funds to file 5 applications overseas. What then? Do you risk it all and just file the application, not knowing if it actually has a fighting chance or if your product will sell well in the market? Do you forgo filing applications into your 5 target markets because you cannot afford the filing fees at this point of time? Again, there is a good news. Malaysia is a member state of the Patent Cooperation Treaty, which is known as PCT. It is a system for filing patent applications overseas. What PCT does is that it allows you some time to delay filing corresponding applications into your target countries while at the same time providing a preliminary assessment on the patentability of your application. Now, instead of having to immediately file corresponding application into all the countries where you want to obtain a patent right within 12 months, you may do so within 20, 30, or 31 months from your initial application, depending on the deadline which the country follows. This ability to delay filing the corresponding applications can give applicants more time to the test market or raise funds to cover the said filing fees. Additionally, when you file a PCT application, your application is reviewed by a searching authority who gives an opinion as to the patentability of your invention. This allows the applicant to see if the application has a good chance of being patented before proceeding to the file application into all the target countries, as opposed to after the application has been filed and a large sum of the fees have been paid. A further advantage of the PCT system is that some countries accept the findings of the PCT preliminary opinion, which significantly shortens the application period in these countries as there is no need for further examination and back and forth communication between the patent office and applicant. In spite of all these advantages, PCT may not be the best choice if the number of overseas applications to be filed is low. This is because a PCT application is an added cost on top of the fees that are payable to file corresponding applications into overseas countries. Please be advised that PCT does not replace the entry procedure into other countries, nor does a PCT give an applicant an international patent, as some may be led to believe. Additionally, applicants should remember that the PCT opinion is just an opinion and should not be taken as indication that the application is sure to reach allowance or will never be granted. In some circumstances, the patent examiner will disagree with the PCT opinion and cite their own objections against the applications or allow an application based on his or her own findings. Let's see the PCT route. To file a PCT application, an application should be filed at the local patent office, which acts as the receiving office. At the time of filing, the applicant must elect an International Searching Authority (ISA) who will perform the preliminary assessment on the patentability of the invention. For Malaysian applicants, there are 4 patent offices which can be elected, which are Australian Patent Office, Japanese Patent Office, South Korean Patent Office, and the European Patent Office. At about 15 months after the date of the priority application, not the PCT application date, the ISA will issue a search report and written opinion on the patentability of the application. If the opinion is favorable, then all is well, and the applicant only needs to look forward to filing the corresponding applications into his or her target countries before 20th, 30th, or 31st month is up. If, however, the opinion is unfavorable, the applicant may file a demand for international preliminary examination together with the necessary arguments and amendments so that the patentability of the invention may be re-evaluated. The ISA, in some occasions, may issue a further opinion, and the applicant may submit further responses if the opinion is still unfavorable. At about 18 months after the priority application date, the PCT application will be published, and this publication will also include the search report and written opinion of the ISA. At about 28 months after the priority application date, the ISA will issue an international preliminary report on patentability, also known as IPRP, based on the written opinion. If a demand was filed, then the written opinion issued after the demand will form the IPRP. In any event, before the 20th, 30th, or 31st month is up, the applicant must file a corresponding application into the target countries based on the PCT application. The application then continues at the national level in the countries where the corresponding applications were filed into. Now let's move into the fourth and the final part of today's webinar, the patent filing strategies and consideration. Now that we know that the two paths available to applicants for filing their application overseas, let us look at patent filing strategies and factors that should be considered. Regional patents. For some countries, a regional patent which has effect in all countries in the region may be applied for instead of filing into each country individually. This is of benefit to both the applicant and the patent officers in the region, as the applicant is able to obtain patent rights in the whole region through one simple procedure, and the patent officers in each country need not replicate the work of another country, especially when the patent office of one country is in the same region does not have the same amount of resources as a more developed patent office of another country in the same region. The following regional patent offices allow a regional patent to be obtained that has effect in all countries of the region. Here are some examples of the regional patent offices. The African Regional Intellectual Property Organization, ARIPO. The Organisation Africaine de la Propriété Intellectuelle, OAPI. Wow, that is mouthful. Okay. The European Patent Office, EPO, the Eurasian Patent Office, EAPO, and the Gulf Cooperation Council Patent Office, GCCPO. Should you wish to know the contracting or the member states of all the regional patent office, it is available online. However, let me share with you the list of countries of each regional patent offices quickly. The ARIPO, which is an organization made up of 19 English-speaking African countries, are listed here. An application for an ARIPO patent can be made by filing at the ARIPO office. The ARIPO office recognizes the priority of a Paris Convention member state and is also a member of the PCT. Second, OAPI. Similar to the ARIPO, OAPI is an organization consisting of 17 French-speaking African countries, which are listed here. Likewise, an application for an OAPI patent can be made by filing at the OAPI office. The OAPI office recognizes the priority of a Paris Convention member state and is also a member of the PCT. Thirdly, EPO. EPO is the executive arm of the European Patent Organization, which has 38 members to date, as listed here, whereby a European application designates all 38 states. And once your European patent is granted, you may also choose to extend your patent to the following countries, like Bosnia and Herzegovina, Cambodia, Montenegro, Morocco, Republic of Moldova, and Tunisia. Corresponding applications at the European Patent Office can claim priority via the Paris Convention, and the European region may be entered via the PCT. Fourthly, EAPO. EAPO is an intergovernmental organization performing administrative tasks relating to functioning of the Eurasian patent system and the ground of Eurasian patents. Member states party to the Eurasian Patent Organization are listed here. There are 8 countries, as you can see. Like the above, EAPO recognizes the priority of a Paris Convention member state, and it is also a member of the PCT. Lastly, the GCCPO. GCCPO is a regional office specifically established for implementing patent law of the Gulf Cooperation Council. It is a political and economic alliance of 6 countries in the Arabian Peninsula, which are Bahrain, Kuwait, Oman, Qatar, Saudi Arabia, and United Arab Emirates. While all countries are members of the PCT, the GCCPO is not a member itself, and therefore, a corresponding application for a GCC patent can only validly claim a priority via the 12 months Paris Convention route, and not the PCT route. Here, I would like to emphasize that the GCCPO is not a member of PCT. Thus, you can only claim a priority via the Paris Convention route. Second in the strategy would be money matters. I feel this is the most top priority for all of us. Cost is, of course, an important consideration for any patent application, as the fees that are payable to the patent office and the patent agent handling the application are no mean sum. Below are some of the extras that the applicant must allocate for when budgeting for their patent application: submission of priority documents. Generally, applicants are required to submit a certified copy of the priority application when filing a patent application overseas. A certified copy of the patent application must be requested from the local patent office so that it can be submitted to the foreign patent office. Translation fees. While applications in Malaysia can be filed either in Bahasa Malaysia or in English, translation of the patent specification is required when filing into countries where the national or official language is not in English. For example, translation into Chinese is necessary when filing into China, and the Thai language when filing into Thailand. As such, applicants should be prepared for added cost to translate any documents which are to be filed at these patent offices. It may be tempting to skimp on translation fees by doing it yourself using Google Translate or after a few hours on Duolingo. But again, since the patent documents are highly technical legal documents, it is not recommended unless you wish to receive objections from the patent examiner and the potential loss of rights due to imprecise or ambiguous language used and pay extra to the foreign patent agent to correct translation errors, which I believe all of us would like to prevent. Requesting examination. In some countries like the US, examination of the application is automatic. In other jurisdictions such as China, Japan, Indonesia, Vietnam, and the European Patent Office, examination of the application is not automatic and must be requested. Failure to file request for substantive examination will result in the application as being deemed withdrawn by the applicant. Publication fees. Some jurisdictions such as Thailand and the Philippines may instruct the applicant to pay the publication fee so that the application may be published for public inspection. Similar to the examination request, failure to pay the publication fee will result in the application as being deemed withdrawn by the applicant. Attending to office actions. During examination of the patent application, the patent office will issue what is called an office action to the applicant, requiring an appropriate response from the applicant to correct any deficiency in the application. These may be an instruction to submit forms which have yet to be submitted, or responding to an examination report which finds that the application lacks patentability requirements such as novelty, inventiveness, and industrial applicability. Maintenance of the application. Typically, payment of maintenance fees vary from country to country. In countries such as Malaysia, the US, maintenance fees are paid after the application has been granted. In other countries such as China and Indonesia, the maintenance of the application begins after the application is filed. Applicants should anticipate such expenses during the pendency of the application, as failure to pay the maintenance fees will result in the application being considered as abandoned by the patent office. Next, the third strategy, which would be the acceleration programs. Post accredited or accelerated examination. Some patent offices may allow expedited or accelerated examination of a patent application if it meets particular criteria. For example, the application is in the national or public interest, the application relates to a green or other technologies for which the government is providing an incentive, a third party is commercializing a product or process which, if the application is granted, will infringe the granted patent, and the applicant is of an advanced age. Second, PPH, patent prosecution highway. Applicants may also make use of the PPH if such an option is available. PPH is the collaborative program that allows quicker processing of one's application based on work product of another patent office. For example, if an application is found to be patentable at the first patent office, the findings of the first patent office can be shared with the second patent office so that the application at the second patent office may be granted on the basis of the patent granted at the first patent office. The rationale behind this program is that since someone has already done the work of examining the application, there is no need to replicate the same effort elsewhere. Malaysia presently has PPH agreements with Japan, EPO, and China. Asian Patent Examination Corporation. The patent officers in Asian countries have joined a cooperative program called ASPEC, which is the Asian Patent Examination Cooperation. Similar to the PPH, ASPEC is a work-sharing program where the results of the first patent office can be used to speed up the application process in the second patent office. Currently, there are 9 patent offices participating in the ASPEC program: Malaysia, Singapore, Brunei, Indonesia, Vietnam, Cambodia, Thailand, Philippines, and Laos. Another important aspect of the patent law is that an invention conceptualized by a Malaysian resident needs to be filed in Malaysian Patent Office first. Thereafter, corresponding patent application can be filed in other countries of the applicant's interest. The above is actually traditional route, which is also in line with the requirements of the law. However, there may be scenarios like the applicant wishes to protect a business method, and such methods are not patentable subject matter in Malaysia. Let's take another scenario where the applicant feels that his or her product has no commercial value in Malaysia. Can the applicant file overseas directly? Won't this be considered against the Malaysian patent law? What can the applicant do in such scenarios? There isn't a reason to be disheartened or feel tied down by the law. In circumstances such as the above, the patent law under Section 23A allows applicants to apply for a foreign filing license and upon receiving the MIPO's approval. Thereafter, the applicant can proceed to file a direct application overseas. Okay, now that you are more aware about filing patents in Malaysia and beyond, let us revisit the following questions. If you all recall, the first scenario was between B and Mr. K. And the question was, can B obtain international patent coverage by filing a PCT application? No. The PCT system does not award an international patent. It is a filing system with the advantage of delaying entry into foreign countries, while providing the applicant with an opinion on the patentability of his or her invention. The PCT system does not replace filing costs for filing into a country and is no guarantee of allowance. Nevertheless, the advantages of PCT system usually outweigh and the added cost for filing a PCT application. The second one is, meanwhile, the scenario was about C having intention to register its granted patent in the Philippines. Can C do so? The answer is C will not be able to re-register his Malaysian patent in Philippines as there is no agreement between MIPO and Philippines Patent Office, IPO PHL, on re-registration of granted Malaysian patents in the Philippines. So, if you wonder whether there is any available registration route at present, yes, an applicant may validate a European patent in any of the countries of Bosnia, Cambodia, Montenegro, Morocco, Republic of Moldova, or Tunisia. Similarly, an applicant for a patent in China may also apply to re-register his or her patent in Hong Kong. The third scenario was on reinventing a thermal solar desalinating apparatus. Can we obtain a patent in the Maldives? What about the rest of the world? At present, the IP of the Office of the Maldives does not accept patent applications. As such, if D wishes to claim patent rights to his invention in the Maldives, he is best advised to publish a cautionary notice so that the public is made aware of his invention. Before moving into Q&A section, let's revisit today's webinar. I have covered the following points here. How to get a patent in Malaysia, that's here. Just to recall, patents are not automatically granted. The applications must meet patentability requirements before they are granted. The patent application must include specification, a request grant of patent, a power of attorney form, and a statement justifying the applicant's right to the invention. Patent application procedure. Filing. First, you need to file a request for a grant of a patent, followed by a preliminary examination and publication of application, substantive examination, and the last one is grant. Now, how to get patent overseas? The application must be filed overseas to obtain patent right in overseas. The process is more or less the same, which includes filing a request for a grant of a patent, preliminary examination, publication of application, substantive examination, followed by grant. The fork in the road, Paris Convention or PCT. Paris Convention is 12 months following date of filing priority application, which is more direct and economical option. PCT. PCT. File PCT application within 12 months following date of the filing priority application. Allows entry into the overseas countries to be delayed. It is an opinion on the patentability of the invention, which will be provided to applicant. Patent filing consideration and strategies. First one is regional patent. Regional patents may be obtained from the following regions: ARIPO, OAPI, EPO, EAPO, and GCCPO. And money matters. Filing a patent application is not the only cost that the applicant has to bear. Applicant must be ready to pay for the following: submission of priority documents, translation fees, requesting substantive examination, publication fees, attending to office actions, maintenance of a patent application. Acceleration programs. Depending on the jurisdiction, acceleration or expedited examination programs may be available to the applicant, which are expedited examination, PPH, and SPEC. And the last one is the foreign filing license. It's your resort to file overseas if Malaysia isn't a market for your product or process. Having said the above, obtaining a patent protection locally and overseas can be a massive undertaking, but with the right preparation, the right strategy, the right budget and patience, you will one day have a global portfolio of patents to ensure that your patent rights are covered in Malaysia and beyond. With now, I will be handing over the session to Ms. Rachel for Q&A. Thank you, everyone.
Thank you, Ms. Shamila. Okay, so about the thing that I discovered. So I discovered that LearnerB actually can be accessed with a mobile app. So those video replays, you can actually download them. And then for me, I do download them and hear in the car as a podcast because hours and hours of traveling, so might as well learn something new, right? So I'll share the link over here. It's only for iPhone app right now though. They haven't, it depends on the Apple iOS app. If the response is good, they'll create an Android app for more people to use. So Daniel, engineer and entrepreneur, interesting. So I guess we'll be expecting some patent from you, inventing something new. Okay, so I've shared the link. So I'll make it a, should I make it a broadcast comment? Broadcast. Okay, so that is the link to the mobile app. Oh, have a US patent file. So not to pry, just curious, what sort of device or item that is patent pending? Curious about the usage, the function. Oh, okay. So, yep, still an ongoing process, not granted yet. Okay, so don't expose the idea yet here. Keep it a secret first. Hope to see. Oh, okay, electronics. Hope to see your product in the market in the future. Perhaps next time we can introduce you for our talk on the whole process of being an engineer, entrepreneur, and how you patent your product. Because I believe those who actually experience it themselves will have actually much more to share than just the theory itself. Like Miss Shamila here, she has, oh, it is published, so no secret. Okay. Uh, what is its function, Daniel? Oh my god, makes me so curious right now. An audience that actually patent an invention. Okay, so I'm gonna unbroadcast the link right now. So you can try out the iOS app. It's pretty useful for me lah. Complication with PCT. I see. So this session, does it help? But I believe you already some sort of know the process, right? It's quite good to have this sort of session, because I believe this sort of session is only available elsewhere if you pay for it or if you are a client of certain firm, they have like internal training. So to have this out there in public, I believe it's quite important. We have a lot of US videos, podcasts, maybe the UK, but we rarely have the Malaysian perspective. So having the Malaysian perspective on this topic, perhaps it could encourage people to invent more, even the simplest sort of invention. If it's novel, I believe you can try to patent it. Yeah, can you patent a design? Oh, no, that one is industrial design, specific function. Hi,
Okay.
hi, Shamila.
Hi, Rachel.
Yeah, so we have quite a few questions. Let's deal
Yeah.
with Daniel first question. I'll broadcast the comment.
So the question is, do you
Yeah.
provide prior search in overseas, US, Europe, China consultation before filing a PCT? It is very costly to file for each country. It is best to gauge the invention for inventiveness before filing. Yeah, Daniel, you answered overseas as well. Okay, moving to your next question. I guess
Next
Daniel has quite a
question.
number of questions here.
Yeah. How does Brexit impact the EPO?
Okay, hold on. How does Brexit impact EPO? What is the current status for Great Britain for EPO? Okay, Daniel, there will be no change to the application process for UK and European patents. Patents covering the UK are granted by two organizations, the UK Intellectual Property Office, UK IPO, and EPO, European Patent Office. None of these two bodies in an EU institution, and they will be continuing to function after Brexit as before. In particular, UK will continue to be a contracting state of the European patent, which is the international treaty as established in the EPO. Currently, there are 38 contracting status in the EPC, 10 more than EU members, including non-EU countries such as Norway, Switzerland, and Turkey. The UK will become another non-EU country, but nothing else will change here. Next question. Daniel again. Okay, how to file US provisional patent as Malaysian, since Malaysia does not provide provisional patent but only equivalent to non-provisional patent. Okay, yes, Malaysia does not provide provisional patent, but we can file a first patent application using minimal information that we have. Within 1 year, which is 12 months, you can file another application claiming priority of your first filing, the one that you filed earlier, and that new application will contain all the information that you can proceed as a complete patent application. So you can abandon the provisional application later on. That's how you handle provisional application in Malaysia. And then Daniel as a US patent, still ongoing process, not granted at electronics, is published, so no secret. I think Daniel's question is not completed here. Now let's go to Tan Kok Chuan. To file patent in Malaysia, how much it costs roughly? Okay, Tan Kok Chuan, actually, I advise you to just email us, that we will share with you the quotation, because generally we won't share our quotation to our sessions here. Daniel, is there any chance to recover failed PCT filing after the due period lapsed? Okay. Typically, Daniel, there's no chance to recover failed PCT filing, but you need more information to advise you properly, so that we will see what the scenario is all about first.
The question is, are you speaking about
Yeah, I can see
Malaysia?
that Daniel missed out the first answer.
Yeah. So perhaps you can repeat the answer for the first question? Okay, can. Because just now a bit laggy. I broadcast the comment now.
Are you speaking about Malaysian provisional patent? First question, okay. Do you provide prior search in overseas? Yes, we do provide, Daniel. We do the search for the
Okay.
overseas as well. Yeah, that is my answer for the first question. If Daniel, you missed just now, right?
Yeah, Daniel, I hope you got it. All right. So the latest question is, are you talking about Malaysia provisional patent?
Provisional patent. Yes, for the provisional question, I'm talking about Malaysian patent application. There's no such a name as Malaysian provisional patent actually, but we filed the initial application.
Okay, so that's it for the questions. Guess there is no more questions already. So should we wrap it up? You need to share your contact, right? Perhaps you can share screen to share the contact to the audience. Shamila, Daniel have another question. We still have a bit of time. Perhaps we can deal with it.
Okay, Daniel, do I need to file anything before going directly to US provisional patent? And yes, you need to file. I was a US resident, but I am back in Malaysia. Yeah, you need to get a foreign filing license. If your invention was conceptualized in Malaysia. That's the answer.
Okay, so I believe that's the end of it. So Shamila, you can share your contact details for the audience to contact you via email or by phone if they have any further questions, right?
Yeah, I've shared here. So please email cash@cash.asia if you have further
Okay,
questions, so that
great.
I can drop you an email.
My name is Rachel. Thanks for logging in today. Thank you to Shamila again. So bye bye from Learnaby. Be happy, learn online.